Danny C. Lee.
Yes, ma'am.
Your Honors, good afternoon. I'm Melanie Lane Diamond of the Fentress County Bar, and I represent the appellant, Danny Carl Lee, the husband in this case. I would like to reserve 3 minutes for rebuttal, if I may, please. This is an appeal of a divorce case. Husband and wife in this case were married for over 20 years when they were divorced by the McMinn County Chancery Court in 2023. Husband's appeal focuses on the trial court's property division, classification, and valuation of various assets. But as an initial matter that I want to address first, we have also asked this court to vacate more than 40 orders that the trial court entered while a motion to recuse was pending. Husband filed a motion to recuse on September 11, 2020, and his trial attorney attempted to present it, or at least brought it up, at a Zoom hearing that was scheduled on another motion for that day. The trial judge declined to hear it because it wasn't properly noticed, and the motion was never addressed again as far as the record reflects. In fact, the trial court went on to enter more than 40 orders in the case over the next 5 years. And it wasn't until the case was appealed to this court and then this court remanded it for a resolution of that motion that the trial court finally addressed the motion to recuse in July of this year. Tennessee Supreme Court Rule 10b provides that once a motion to recuse is filed, the trial court, quote, shall make no further orders and take no further action on the case except for good cause stated in the order in which such action is taken. In none of those 40, I think it's 42 orders that were entered after the motion to recuse was filed, none of them mention the motion, none of them state any good cause why the trial court was essentially violating Rule 10b of the Tennessee Supreme Court. So we are asking initially that this court vacate those 42 orders and remand the case for a rehearing on those issues, including the final hearing. In addition, we're asking that the trial judge be ordered to recuse herself on remand. Should this court not grant that request, we have also raised property division issues. I'd like to...
Counsel, excuse me for interrupting. At some point in time during the course of these orders that were entered, was an amended motion to recuse filed, and did the court address that?
Yes, Your Honor. I filed that on remand to correct what I think was a fatal error in the initial motion, which was it was not sworn to. I would point out that it is identical to the original motion. It doesn't add any new cause of action, any new issues. So, yes, it was.
So it is undisputed that the initial motion that was presented during the Zoom hearing was not supported by an affidavit. Is that correct?
Well, that's correct. It is undisputed. I mean, I can't deny that. But I would say it was presented. It was not addressed or heard at that Zoom hearing.
Did the trial court orally make any ruling with regard to that initial motion?
No, Your Honor, and I believe that the transcript of that hearing is in the record. The trial judge said something to the effect that, you know, I can't address this if it's just been filed a few minutes ago. I'm going to give the other side time to respond. And that's all that was said about that motion. The trial court then went on to address another motion that was properly set, properly noticed for that Zoom hearing.
And in connection with that subsequent motion, the amended motion to recuse, did the court ask of counsel whether they had any objection to the court going forward, or would waive any objections to the court hearing it to that point in time?
So the amended motion to recuse was not heard. It was just the judge just addressed it in an order, a written order. There was no hearing on it. However, I do think there was a hearing on some motion in 2022 in which an accountant from the accounting firm in which the judge's husband was a partner, I believe, came to testify. And the trial court did say, is there going to be any objection to him testifying? And both attorneys said no. But the motion to recuse was not addressed at that time. It was simply, is there any objection to this accountant testifying?
Was ultimately an order entered with respect to that amended motion?
Yes, yes, Your Honor. In July of this year, the trial court entered an order.
Thank you.
Going on to the property issues, the first issue that we've appealed is the trial court's valuation of a business that was owned by the husband, owned by the parties, and primarily run by the husband. Both husband and wife hired experts who came in and gave testimony as to the valuation of that business. Husband's expert found that the business was worth a negative $300 and something thousand, and the wife's expert testified that the business was worth nothing. In spite of that, the trial court found that this business was worth $565,000. The reasoning is not crystal clear, but the order does say that it was worth $400,000 before the husband's actions dissipated it. The trial judge did not explain exactly how the husband's actions had dissipated it, or how she had come to that figure of $400,000. But it is stated that she believed the business was worth $400,000 before the husband dissipated it. She takes that figure and she goes on to add $165,000 that is because there was a commission the husband had testified about that the company might receive. It was due to receive. It was supposed to have already received, but it was due on a machine that had not yet been produced. And so the trial judge found that that $165,000 would increase the business's value by that amount, and that's how she came to the $565,000 value. I would argue that even if the company were to receive that commission, it would not retain the entire amount. Proof in the record is that salespeople, the company hired or employed contract salespeople who received 50 to 75% of any commission that the company received. So certainly at least 50% of that would go to the salesperson, and of course there would be overhead, other expenses. It is, with respect to the trial court, it is illogical to conclude that the business would be increased by the total value of that commission. So we do ask this court reverse the finding, the valuation of the business at $565,000, find that it's worth nothing. The second issue regarding the property has to do with what the trial court and what the parties called the Etowah House. There was a home in Etowah, Tennessee, that was owned by the wife at the time the parties married, and it was encumbered by a mortgage. I don't believe the record reflects how much, but it was encumbered. During the marriage, the parties refinanced it twice, and more importantly, they made significant improvements to it, and wife paid off the mortgage during the separation. The trial court found this house to be the wife's separate property for a couple of reasons. First, because she never put the husband's name on the deed, and second, because she paid it off during the separation. Neither of those reasons would justify finding that there was no marital interest in this property. The law is very clear that equity accrued during the marriage is marital property. It is also clear that any funds acquired by the parties, earned by the parties up until the date of the final divorce hearing are also marital. So the money that wife used to pay that house off were marital funds. And husband certainly has an interest in that home, and the trial court's finding that he had none should be reversed. The next issue that we raise has to do with the overall distribution of the marital estate. There are a lot of figures in the orders in this case. There are a lot of numbers in this record. But at the end of the day, what it really comes down to is that wife received almost $1.5 million as her portion of the marital estate, and the husband actually received a negative $464,000. Not only did wife get this home as her separate property, she got $561,000 in cash that was being held by the court clerk as I think proceeds from the sale of some real property. She also got several pieces of real property. Husband was saddled with over $800,000 worth of debt. This company that's, in the opinion of experts, worth nothing, and some personal property, I think maybe one piece of real estate. His home that he had owned prior to the marriage was sold, and the parties' debts, some of the marital debts were paid from that. We are asking the court, as an initial matter, to find that The failure to deal with a motion to recuse and to enter all those orders while the motion to recuse was pending was error, and that they be vacated and remanded for resolution of those issues. In the alternative, we are asking that the court reverse the valuation of the husband's business, find that the Etowah house was actually marital property and that husband has an interest, is entitled to some portion of that value, and to vacate the trial court's property distribution, remand it for a resolution, a fair resolution with more accurate valuations and a proper classification of the Etowah house. Thank you.
You have your time for rebuttal. Yes, sir.
Good afternoon to the court. I'm Randy Sellers from the Bradley County Bar. I represent the Appellee, Mrs. Lee, who's with us today in this case. First of all, I want to point out some facts of note that were maybe not talked about a little bit. This case has been pending since 2018. That's significant in a couple of ways, because during that 6-year period, or that period of time, my client continued to pay her bills, one of which was the mortgage on this house that was separate property. And during the same time, Mr. Lee accrued debt and didn't pay bills. He accrued several hundred thousands of dollars in what he calls shareholder loans. His company, he's the sole stockholder. It received a SBA loan of over $400,000. So I don't think you can say that house is marital property when, on the other side of the coin, Mr. Lee is depleting or dissipating the assets of the marriage. There have been multiple petitions filed, multiple contempt citations. Mr. Lee has filed various motions that would tend to delay, put that mildly, sale of properties. There have been several attorneys in this case. I'm the only one for Mr. Lee. I think Ms. Lee, Mr. Lee had, I think, 6 attorneys, including counsel here today, and then 2 stints when he was representing himself. There's a significant estate. There was a farm that was sold. There are rental houses. There's a huge amount of personal property, including things like antique automobiles that Mr. Lee received. So I don't want the court to just think that that personal property is a couple of items of furniture. It was not. It's substantial. What I'll call wife's mother's house that's in contention today, and this corporation called PTI, which both parties agreed was marital property, and that Mr. Lee is the stockholder. There were early sales of property by court order to fund forensic accounting, a business valuation, appraisals of both real and personal property, which that was, again, substantial. And there were early sales to stop the statutory injunction violations by Mr. Lee. An example of that is he was selling cattle without permission of the court or agreement. At trial, Mr. Robert Vance did a business evaluation. I think this court is familiar with Mr. Vance. While this appeal's pending, this court, through Judge McBrayer, came down with the decision of Garrett v. Garrett, which also involves business evaluations, and it has a paragraph or so in it that talks about what the court can consider in determining the number for a business valuation. So it's not in my brief since it was after that was done, but I'd ask the courts to take a look at it. It was filed June 30th of this year, 2025.
It's not in your brief. Is it in the record?
It's not in the record, Your Honor. This has come out since this appeal was pending. I'm just asking the court in argument. Is this additional proof that should be in the record? No, it's just the court's opinion in another case that involved business evaluations, just as to what this court found was the relevant law in another case.
Okay, if you want us to consider another court's an opinion, then you need to send it to the clerk's office to be delivered to us. Okay?
Yes, sir. Okay. And again, Mr. Vance did find there was a zero value, but what he said that wasn't included is that this evaluation did not address recent receivables, and counsel mentioned one of those that had a $165,000 commission that was yet to be received from the sale of a machine, a piece of machinery, and that would increase the value if, if that commission were received. So it is correct that the judge did take the $400,000, which was part of an SBA loan that Mr. Lee received for the corporation, that would increase the value by $400,000 plus the $165 to come to the $565 that they are saying is erroneous. And that's in the 21-page master asset list that's attached to the judge's order where she assigned that value.
And the PPP loan is something that nobody seems to know where the money went. Is that correct?
Yes, Mr. Lee couldn't explain where anything went virtually, including this SBA loan.
Is that something he's supposed to pay back or no?
There was no guarantee signed by Mr. Lee on this document, just SBA loan to the corporation, which I think everyone was astonished at. The form itself does ask for a guarantee. In addition, there were criminal contempt citations during this case that affected Mr. Lee's credibility. For instance, and I cited this on page 12 of my brief, for violation of trial court orders, including hiding assets, moving money out of state, incurring significant debt during the divorce action, depriving the wife of access to bank records, failure to pay appraisers, failing to pay settlement funds to the wife. And as a result of those types of things, he was sentenced to 60 days in jail, and which he did not serve, has not served at this point, and a $350 fine, I believe. Addressing the recusal, I was there at the hearing. I don't remember it being a Zoom hearing, but it was a hearing that I had noticed on other issues, not involving recusal. We didn't even know there was a recusal coming down the line. And Mr. Robert Meeks was the attorney, and he told Chancellor Bryant that he had just a few minutes before that hearing filed a motion to recuse. She asked him what it was about, but said, I don't have that, so I don't, you can tell me what it's about, but I'm not hearing that today. It's not noticed for hearing. And it involved, apparently, as counsel said accurately, that the potential witness that wasn't testifying that day, but a potential witness was a member of an accounting firm that the chancellor's husband was also in. She did not rule on that day because it wasn't set for hearing. There was no action asked for, actually. The attorney presented an order to me to approve for that, what she did, basically saying, I'm not hearing that. And I gave him permission to sign, and he never presented it to the chancellor. That's what happened there. Now, 2 years later, and again, it did not have an affidavit. It didn't comply with the rule, Supreme Court rule. 2 years later, we're at a hearing again, and this witness was called at that hearing. This person, member of the firm, the chancellor's husband. Chancellor stopped the hearing, asked, and it's in the transcript of that hearing, asked if anyone objected to her continuing over the case given this scenario. Mr. Lee's counsel was asked, and I was asked, and we both said no, Your Honor. And so I simply believe that it's a waiver, it's a moot issue, and it's not something that this court should seriously consider doing, very respectfully. And the hearing proceeded with that witness. So that wasn't recorded in an order, what she said or did, again, because no one ever brought up the motion to recuse again. And we're there with another attorney on that day. It wasn't Mr. Meeks. He withdrew right after the day that we had the original hearing. And then during appeal is when the amended motion was filed. It was remanded during this appeal. It already started 3 years later, or 2 years later. And that's when the chancellor put down the order indicating, again, this doesn't comply with the rule. I'm denying it, and that's the end of that. So we believe that this court should find at the worst that the parties simply waived the issue and the court did not do anything wrong. And I think one of the cases that counsel even cited in a reply brief had a similar scenario where an order wasn't put down. The court found it was error but said it was harmless. So at the most, that's what this should be held to be, I would think. The next, let's see, I'd like to take up the evaluation scenario. I've already really gone through how the court found the 565, but Again, it did not include the proceeds of the SBA loan that the corporation got, but could never be traced anywhere. Where are the proceeds, Mr. Lee? He couldn't explain that, other than in generalities. Had a massive amount of paper in this case, but no paper could be produced to show that. Where does money go? And again, we think that the court is within her prerogative to take into account not only the business evaluators and their opinions, but all relevant evidence to come to a range, and that's what she did, and found that it was 565, which she did assign to him. As to the overall division of property, I'll address that next. The court made substantial findings in this 18-page opinion. And again, she ties this business evaluation up on several pages of that opinion, which, by the way, her opinion, the one I'm referring to, is located at the transcript of the record, volume 4, pages 617 through 635. And in 4 different places, she comments on this commission, this 165 commission, and comments on the 400,000. So it's all tied together to show why she came up with 650. But again, credibility was crucial in this case. Husband's lack of credibility was found by her due to his hiding assets, his untruthfulness, his moving assets continuously in violation of the statutory injunction. The court literally said, in 25 years on the bench, this is the worst on this kind of conduct that I've ever seen. Made that finding. And you look at the string of events even to start this case. Mr. Lee had, we introduced into proof things that he had provided to us, showing that he had taken out like a $500,000 shareholder loan, not just weeks before the divorce was filed, and it was signed weeks before the divorce was filed, and then it was notarized after the divorce was filed. And then 8 days later, there's a $650,000 loan from the corporation to him, again, signed before the divorce and notarized after the divorce began. That's how this case started. We had to try to untangle that. So again, credibility was huge in this matter. As to the overall division, I don't know how the council is characterizing the figures, but so be it. But the initial order was that pending the sale of this farm I mentioned a minute ago, Mr. Lee received, and she sets this out specifically, $1.3 million of the marital estate, Mrs. Lee $790,000, and then the additional $802,000 was the gross amount received from the farm sale. And of that 802, there were 4 business loans paid off that Mr. Lee had that were cross-collateralized with other marital property, including rental properties and including this piece of property. Well, no, not including that piece of property. My client had paid it off. But including the rental properties and other land that the parties had. There were 19 mortgages taken out during this marriage. So that's why the court had to try to disassemble all that and had paid off to his benefit these 4 loans. That brought the proceeds down to about $550 or so. And then that portion was taken to equalize the awards to both sides. On the wife's separate property, there is the facts were that she'd resided, it was her mom's property. She had resided there, my client, before the marriage, obviously. It was titled in her name always, never titled in husband's name. The parties only lived in that house for 2 months while there were repairs were being made on the farmhouse. And then here was the testimony about what that was, the mortgages on that property and how it related to, you're going to have to pay these off. Husband testified that the improvements on the wife's mom's property, which one-time improvements to expanded the square footage a little bit, was payment for putting an $86,000 mortgage on the home that was used for business purposes. And then my wife paid them off during the separation. My client, the wife, paid them off during the separation out of her own income. She's a school teacher. That's what she paid it out of. So that's how that happened, and we think under the circumstances, the court properly found it to be separate property of my client. Court have any questions of me?
I hear none. Thank you very much, sir.
Let me agree with Mr. Sellers on one issue. The personal property in this case was significant compared to what we see in lots of divorce cases, but it was pretty small compared to everything else. This was a very large marital estate. As far as the SBA loan, I would respectfully disagree with Mr. Sellers in that the husband did testify as to how he'd used the money. That's cited on page 27 of my brief. He used it to make a down payment on a machine that they had ordered from Spain, to pay 2 commissions that were owed to salespeople, to pay certain marketing expenses. After those payments were made, there was $44,000 of the SBA loan left, and the husband used that to pay wife's attorney's fees and some expert witness fees, which I think he had been ordered to pay by the trial court. So he did give an account as to how that money was spent. Mr. Sellers is correct that husband accrued debt primarily through the business during the 5 years that this divorce was pending. However, he also maintained other debts, paid down other debts, paid off some other debts. It was part of the normal course of business. That's how his business and how many businesses work. As far as the shareholder loans, husband did take some shareholder loans during the pendency of the divorce. However, it was the same kind of thing that he and wife had done since the very beginning of PTI. They always took really compensation. They're called shareholder loans, but it's really more like a form of like a partner draw in a partnership or a member draw in an LLC. At least that's what it appears to be. I think everybody agreed at the trial that no one expected those loans to be repaid. And finally, I would just say that the delay in the resolution of this case should not affect this court's analysis of property distribution. It did take a long time. There were lots of motions filed. I know, I've read the entire record, but that has no bearing really on the distribution of the marital property. If the court has no other questions for me, that's all.
I hear none. Thank you very much. I want to thank you both for your presentation in this case. We will review the case as we do and prepare an opinion and a judgment on this case. You should receive our opinion within a reasonable period of time. If there's nothing further, then these parties may be excused.